In this video, I'm going to answer the following question. How much money are failure to accommodate cases worth for disabled employees? My name is Branigan Robertson, and I'm an employment lawyer. This is the final video in our 5-part reasonable accommodation video series. At the end of this video, you will understand what kinds of damages disabled employees are entitled to if they win their lawsuit. You will understand how lawyers value cases, and you will start to understand why some cases are worth millions of dollars, yet others are worth nothing. But before I start, you should also know that although I'm a California lawyer, I'm filming this video for workers all over America. But this is not legal advice. If you need legal advice, you should call a lawyer in your state. If you worked in California and you got fired, you can call my office for a free consultation. I'll put my contact info on the screen at the end of the video. Let's get going. In general, there are 3 types of damages that you can win in a failure to accommodate lawsuit. Number 1, lost wages. Number 2, emotional distress. And number 3, punitive damages. After we get done examining each one of those, I'm going to shift gears and talk about settlement value and what you can expect. But don't skip ahead to that, as it won't make any sense unless you first watch the other parts. The bedrock of value to most reasonable accommodation cases are the employee's lost wages. If you made $100,000 a year in salary and you request a reasonable accommodation, but it's denied and then you get fired, you're no longer earning $100,000 a year. When we say lost wages, we mean exactly that. The wages you are no longer earning because you were fired unlawfully. But to receive lost wages in a courtroom, you must first have been fired unlawfully. So if you were fired legally, obviously you're not going to recover any lost wages in court. Similarly, if you quit the job rather than being fired, you are also not allowed to recover lost wages in a lawsuit. The only exception to that rule is if your termination can be classified as a constructive termination. You might have heard that term before. I made an entire video about constructive terminations, and if you quit your job, I highly recommend that you watch it. But generally speaking, in 99.9% of cases out there, you must have been fired unlawfully before you can recover lost wages. Well, okay, Branigan, assuming that is true, how much lost wages can you recover in a lawsuit? Well, that depends on several factors, such as how much money you were earning, right, at the company that fired you. It also depends on how long you were unemployed after you got fired. And it also depends on how much money you're now earning at your new job. And it also depends on how much the jury thinks that you're going to lose in the future after the verdict has been reached. Generally, we break all these damages down into 2 major buckets: past lost wages and future lost wages. I think the best way to explain this is with an example. Let's assume that you were earning $100,000 a year in salary at the old job, and you were earning $10,000 a year in bonuses and $10,000 a year in benefits. Okay, that's a total of $120,000 that you're now losing because you got fired. Let's examine this out step by step. Let's assume that you got fired right here, which is January 1st. And despite your best efforts of looking for a new job, you were unemployed for an entire year. How much money have you lost so far? Well, that's obvious. You've lost $100,000 in salary, right? $10,000 in bonus and $10,000 in benefits. So you have lost for that entire year 120 grand. Okay? Easy. But life is not that simple, right? Let's assume on January 1 of the following year, you find a new job right here. January 1st. Okay, so you're unemployed for an entire year. Now you found a new job. Well, at your new job, how much money are you making? That's totally relevant. Let's assume you're making $70,000 a year, but $5,000 a year and $5,000 a year in bonus and benefits. That's a substantial decrease in what you were earning before, right? That's a total of $80,000. Okay, big difference from 120. So you got that new job. Well, how much are your lost wages in year 2? That's obvious, right? You just do simple math. You've got $30,000 in lost wages. You've got $5,000 in lost bonus and $5,000 in lost benefits for a total of $40,000 of losses in the second year. So what are your total lost wages? Well, that depends on when the trial verdict happens, right? If the verdict happens, you're looking in the past. So let's assume, for simple argument or simple example, that your verdict is on January 1st at the start of year 3, and you win. Cool, awesome, you've won. What is the jury going to award you in lost wages? Well, they're going to look at the past, right? And they're going to say, oh, he lost $120,000 the first year and $40,000 the second year. That's $160,000 in past lost wages. But that's not the whole story, because going forward, you have future losses because you're making less than you were before. So the jury is going to make an estimate, a projection based on of what you're going to lose in the future. And they're going to use economists, which I'll talk about here in a second. But let's just continue our example, and let's assume that you got a raise at the start of year 3 on the same day you won your verdict, and your raise goes to $80,000 a year in salary, and then you get up to $10,000 in bonuses, but your benefits stay the same. Okay, what are your future lost wages? Well, again, it's simple math. We just pencil it out. We go, okay, $80,000 is 20 less than 100, so you're losing $20,000 in year 3. You're losing $5,000 in year 3, and you're losing $5,000 here. Right? So that is, oh, I'm sorry. Zero, but you're losing $5,000 here for a total of $25,000 of losses in year 3. Now remember, the jury's projecting that, so it's never perfect because you don't know what the future holds, but they're going to make an estimate based on the economists. So the same thing is going to happen for the next 3 years, and then the jury thinks, hey, we've predicted far enough into the future, we're going to just leave it at that, at 3 years of lost wages, right? So what does this total up to? Okay, that's obviously $75,000 in future lost wages that the jury has estimated. So your total lost wages are 160 plus 75, which equals 200. Let's just do it right here. $235,000 in lost wages. And that is a very rudimentary, simple example on how we estimate lost wages. The next big category of damages that the jury can award is emotional distress. This is often called compensatory damages. Regardless of the name, these are damages meant to compensate you for the pain and suffering that you go through as a result of the unlawful termination. These are monetary damages for emotional harm. In genuine employment cases, these damages can be very large. but they're also much more difficult to prove than lost wages, right? They're much more touchy-feely. They're not based on math. The jury is awarding you money for the trauma done to you because you were fired after you asked for a reasonable accommodation, right? Because you're disabled. Lawyers will hire psychological experts who will examine you before trial to build up a damage profile or lack thereof, and the lawyers will put those experts on the stand during the trial, and they will testify about the harm done to you. Moreover, your lawyer and the opposing lawyer will ask you a lot of questions about the impact that the termination had on you. We might even call your spouse, your parents, siblings of yours, or close friends, and ask them to get up at trial and testify as to what the termination, how that impacted your life. In genuine employment cases, we cannot just allege that you were harmed emotionally and say, give us millions of dollars. No, the jury's not going to buy that. We have to prove it. And the defense lawyers are going to do their best to show that you're exaggerating, embellishing, or lying about the things that happened to you. Let's continue with our example, okay? Let's say the experts have examined you, and your lawyer believes that you were harmed in the range of $250,000 to $500,000 in pain and suffering damages. Let's say you have a strong case and a very good lawyer, and the jury awards you all $500,000. Hooray, right? That's awesome. Well, in some states, like California, yes, it's a legitimate awesomeness, right? If the jury gives you $500,000 in compensatory pain and suffering damages, you get to collect all of it. California law does not put a cap on these damages and allows you to collect the full compensatory award. Unfortunately, in most states that only use the Americans with Disabilities Act, or the ADA, which is the main body of law when it comes to reasonable accommodations, I have some bad news. The ADA puts a cap on compensatory damages. This means you cannot be awarded more than what the law allows. Well, okay, what are those limits? Well, for employers that have between 15 and 100 employees, the cap is only $50,000. For employers with 100 to 200 employees, the cap is $100,000. For 200 to 500 employees, the cap is $200,000. And if you have over 500 employees, it's $300,000. What about employers with less than 15? Well, if you saw the earlier videos in the series, you know that the ADA does not apply to employers with less than 15 employees. So if you work at a company with less than 15 employees and they fail to accommodate you and they fire you, you're not going to collect anything because the law doesn't apply at all. So look, the whole point in me discussing all of this is that if you are located in California, you can collect the full emotional harm damages done to you. You can get the full $500,000 in our example, and you get to keep it. But outside of California, depending on the size of your employer, it's likely that the judge is going to cut your emotional damage award. So let's say you worked at a company with more than 500 employees and the jury awarded you $500,000. The judge is going to chop it down to at most $300,000. Next, let's talk about punitive damages. What are punitive damages? Everybody has heard about them, but what are they in employment disability, discrimination, or retaliation cases? It's pretty simple. Punitive damages are damages that the court awards in order to punish the defendant for egregious conduct and deter them and other companies from doing the same behavior in the future. It's a punitive measure. Unlike lost wages and emotional distress damages, which aim to make the employee whole by covering his or her actual losses, punitive damages are about punishment or deterrence. They aim to punish the wrongdoer because they acted with malice, oppression, fraud, or with a willful disregard to the rights of others. And they're really meant to deter the company and other companies from engaging in similar conduct ever again. And we've all heard about large punitive damages in the news, right? We've heard about these massive verdicts that attract a lot of media attention because of the egregious nature of the facts or the large dollar numbers attached to those big verdicts. But in all reality, punitive damages are rare. They don't come around all that often, especially in employment cases. I estimate that about 98% of employment cases ultimately settle before trial. And then of the small number of cases that go to trial, maybe 1 or 2 out of 10 will lead to a punitive damage award. So these awards, although very large, are also quite rare. Moreover, just because you hear about a big verdict in the news doesn't mean that the employee and their lawyers are going to collect it. There are a number of limitations on punitive damages. These are legal limitations that check the size of these things. Number 1 is the size of the company. The financial size of the employer may be a limiting factor. Punitive damages are meant to punish the company. If it's against a large corporation with enormous profits, a large $10 million punitive damage award might be legally appropriate. Otherwise, upper management might not even notice. It'd be a rounding error. After all, $10 million to a billion-dollar company is a rounding error. On the other hand, a $500,000 punitive award against a small corporation with thin or no profits might be too large in the eyes of the court and overly harsh on the employer. The size of the employer matters, and the jury is going to use the company's financial statements to decide how large or small of an award to give the plaintiff. Number 2, the burden of proof is substantially higher to win punitive damages than in other things. In civil cases, like failure to accommodate discrimination cases or retaliation cases for that matter, you don't have to prove your case beyond a reasonable doubt. That's for criminal cases. In civil cases, you win if you convince the jury that the company broke the law on a preponderance of the evidence basis. You can think of this burden of proof as like the scales of justice. If the jury thinks it's more likely than not that the company discriminated, then they have to find in favor of the employee. Now, on the other hand, this is where it gets a little bit dicey for punitive damages. In order to win them, you have a much higher burden of proof. Right? And the burden of proof is a clear and convincing standard. Generally, the standard is that you have to prove that the company acted with malice, oppression, or fraud, and you have to prove that on a clear and convincing basis. This is much harder to do than what most people realize. Under the ADA, no punitive damages are allowed in cases where the employer showed that it made a good faith effort to engage in the interactive process, right? If you remember the interactive process from video 2 or 3, if they have a good faith, if they have evidence to show that they engaged in that process in good faith, punitive damages are off the table. All right, number 3, ratios matter. The United States Supreme Court has put a cap on punitive damages. They believe that the ratio of punitive damages to compensatory damages, which is lost wages and emotional distress, should be reasonable. Well, what does that mean? Well, courts have limited punitive awards to no more than a single-digit multiple of compensatory damages. What does that mean? Great question. Courts will not allow the punitive damage award to be more than a single-digit multiple, the highest being 9 times. For example, let's say you win $1 million total in lost wages and emotional distress. Okay? The court will not allow more than 9 times that amount on top in punitive damages. So no more than $9 million in punitive damages. If the majority awards $3 million in punitives, fine. $5 million, fine. $9 million, fine. But $15 million would violate this ratio, and the court would chop it down post-verdict or in an appeal. So what does this mean for reasonable accommodation cases? How big can these cases get? Well, if you've been listening carefully, you can see that they can get very large depending on a variety of factors. If the company flaunts its legal obligations to reasonably accommodate workers, and if that company terminates a worker because they requested a reasonable accommodation, and if there's evidence that suggests that the company was proud of the fact that they were ignoring the law or they relished in the act of discriminating against the employee, then it's very possible that the jury is going to be really angry at the company and award a large amount of punitive damages. If you paid close attention to this video, then you understand why now it's very difficult to predict the value of a case at trial. Well, what about settlement, Branigan? Good question. If most cases settle, how do the lawyers come to an agreement regarding the value? That's a really difficult question to answer, but I'm going to give it a shot here, okay? First of all, you should understand that even if the case settles, it doesn't mean that the parties agree on the value of the case. They never do. A settlement is a compromise. The company is agreeing to pay you money to avoid the risk that a jury is going to award you more money at trial. On the other hand, you are agreeing to receive less money than you think you could win at trial to avoid the risk of a loss. When you settle, both sides are buying certainty. I go much deeper into this subject in my video called How to Get $1 Million Plus Settlement. It is far more detailed than I have time to explain here. So if you want to know more about why settlements get big, then I recommend you watch that video. With all that out of the way, here is how settlement actually works. In most cases, your lawyer will first try to get a mediation scheduled. Mediation is a semi-formal procedure to try to facilitate settlement discussions between the opposing parties. The parties hire a mediator, who is usually like a former judge or an experienced negotiator, to come in and facilitate discussions between the two sides. I won't get too far into the weeds, but on bigger cases, mediation is usually necessary to come to a settlement. Once the mediation is scheduled, you and your lawyer need to come up with your starting number. Now, clients always get really excited when we start talking about numbers, but people should defer to their lawyer's experience here, because experience really matters when it comes to negotiating. Your lawyer will estimate your lost wages. They will try to value how emotionally harmed you are in comparison to other cases that they've had handled in the past, and they will evaluate the chances of a punitive damage award. Your lawyer will use his or her years of experience to form a best case scenario, and then they're going to factor in a judicial award of attorney fees on top of that best case scenario, which I'm not going to get into that in this video. On the day of the mediation, your lawyer is going to have this big long brief and submit that to the mediator and give him or her your starting number. And that starts the very long and arduous process of arguing over liability and damages. The negotiation could last just a day, but it could also last weeks, months, and sometimes even years. How aggressive you are in pushing for a higher number depends on how much legal leverage you have on the other side or over the other side. Reasonable accommodation cases can be worth a whole heck of a lot of money, but they can also be worth nothing. It all depends on how strong liability is, how significant the damages are, and how willing the company is to pay to make it all go away. At the end of the day, every single case is dramatically different. This concludes our 5-part reasonable accommodation video series. If you found this video series to be valuable, please hit the like button and subscribe to my channel. If you are a California employee and you got fired after requesting a reasonable accommodation, please don't be afraid to reach out to my office for a free consultation. Thanks for watching. Have a great day.